Okay, this video is going to be an introduction into something about contract law. I'm going to, on this one, talk about offer and acceptance. Offer and acceptance. So in law, before a contract's formed, there has to be an offer, and then the offer has to be accepted. Within law as a subject, there's a lot of discussion about what constitutes an offer and what constitutes an acceptance. There has to be a consideration, and this is basically a payment. If there's no consideration, there's no contract. So if someone, for example, says, would you look after my dog, and the person says, yes, I will look after that dog, and you don't pay them anything and they get no other benefit, and there's no other, there are no other circumstances related to that. As far as contract law is concerned, there isn't a contract there because there was no payment offered. So it would simply be someone under those conditions out taking actions which are outside of contract law. An early part of law that a lot of people talk about is whether in trying to establish whether an offer has been made, is whether something's bilateral or unilateral. So really, for that we're talking about whether there's an implied offer as a result of someone taking action. And there's a famous case in English law called Carlisle versus Carbolic Smoke Ball. So if you Google that, you get a lot of information about it. Basically, in this case, there was a newspaper advertisement in which someone was offered money if they had used this thing called a smoke ball, and there were some medical benefits claimed, and the legal question was whether that constituted an offer, and when in buying the smoke ball, did someone actually were they actually accepting the offer? And the decision was that there was an offer, because in the case it was actually an offer, because in the case the buyer of this smoke ball had actually acted on the information given by the advertisement, and the court found there was no need to communicate acceptance. So this basically was a unilateral offer. In other words, the acceptance was implied in the actual purchase itself, and this is very distinct from a case when you normally buy something, because usually when a retailer offers something, it's what's called an invitation to treat, and it isn't actually an offer. So if you simply go to the shop and buy something, the actual situation is you offer to buy something and then they accept the offer, not the other way around. They don't offer to sell. So it's actually a different interpretation. But in this particular case, there was an advertisement and it constituted an offer because there were claims being made about the benefits of the smoke ball, and the smoke ball was then subsequently used, and it was found that the benefits were not to be had, and therefore the company had a liability. I'm going to stop the video here because I'm going to keep all these videos short. Law, needless to say, is a very large subject, and I've only cited one case there, one of several hundred that are relevant, so I'll move on to the others in subsequent videos.